Hello and welcome to this last content slam for family law. It's all about the contemporary issues section. There are four which we need to be looking at: recognition of same-sex relationships, the changing nature of parental responsibilities, surrogacy and birth technology, and the care and protection of children. Let's begin by looking at the recognition of same-sex relationships. Traditionally or historically, there was no particular prejudice against people engaging in same-sex relations. The ancient Greeks, in fact, looked upon it favourably. Older men were encouraged to have a relationship with younger men, which was of a sexual nature, designed to assist that younger man through life. However, the Judeo-Christian religion or perspective developed a general dislike towards this form of relationship, and that's what we imported into Australia. So the legal responses have largely focused on being heteronormative, which means that heterosexuality is seen as being normal, or the way that people should live their lives. So homosexuality was actually covered under the Crimes Act for a long time and was a criminal offence. However, this was first removed in Australia and South Australia in 1972. However, New South Wales didn't get there until 1984. Significantly, the Criminal Records Amendment Historical Homosexual Offences Bill 2014 removed any historical criminal record stemming from a homosexual charge. So somebody would no longer be guilty of an offence for homosexuality after the 1984 amendment. However, they would still carry that around as having a criminal record. This 2014 Act finally removed that. So protection from discrimination is one aspect where the law has improved. We now have Section 49, the Anti-Discrimination Act 1977, specifically outlaws discriminating on someone based on their sexual preference. Someone who breaches this can face fines of up to 3 months in prison or fines. Also, under the Commonwealth legislation, Section 5A of the Sex Discrimination Act, discriminating on someone based on their sexual preference is also prohibited. A key improvement has also come under the De facto Relationships Act. De facto relationships are for people who don't get married, however, cohabitate for more than 2 years. This process can be sped up if people purchase property together or raise children together. However, there was an amendment to this in 1999, and the De facto Relationships Act was changed to the Property Relationships Act 1984, and this was extended to include same-sex couples. So this gave them all the same rights as a de facto couple, such as the rights to property, the rights to spousal maintenance, and the right to parenting rights, which could all be pursued in the family law court. The Same-Sex Relations Equal Treatment Commonwealth Laws Act 2008 was a catch-all introduced by the Rudd government, designed to amend, or did in fact amend, 84 pieces of legislation, which in one way or another discriminated against same-sex relations. This could be giving people the capacity to turn off life support for a loved one, or for a same-sex loved one, collect a pension if a same-sex partner was killed while fighting in the Australian Army. And it also changed the definition of family within the family health insurance to allow same-sex couples to qualify for this cheaper and more comprehensive form of health insurance. A key limitation, though, has been the Marriages Act in 1961. The Marriages Amendment Act 2004, Section 5, passed by John Howard, actually inserted into the Act at Section 5 a definition for marriage which expressly prohibited same-sex relationships. This was the definition pursuant to Hyde and Woodmansey, which is a relationship entered into life voluntarily between a man and a woman. However, another key piece of common law in this area was the Commonwealth and ACT 2013. This is where the ACT passed legislation allowing for same-sex relationships. Clearly, marriage is a federal matter under the Constitution, and therefore the High Court found that the ACT legislation could not stand. But this has been an important step forward, or an important attempt to step forward. There's some key media in here. In 2015, Ireland had a referendum which eventually allowed same-sex marriage, and in June 2015, the American Supreme Court held that same-sex marriage was legal in all states of the USA. However, Australia still does not have this recognised. Watch this space. It is highly likely to change in the coming years. Non-legal responses to this matter are all about changing attitudes, particularly to the issue of same-sex. So, for instance, Get Up, which is an NGO, has produced a video campaign which is viral, which talks about the fact that the love share between same-sex couples is as important as heterosexual couples. Marriage Equality is also another NGO which tried to change it. One of their most obvious campaigns has been to get people to change their social media profile to an equal sign or to a multicolored gay flag to show, so people can show their support for same-sex marriage. These non-legal responses are largely about trying to show that people are willing to accept this change and the government needs to catch up. Let's move on to changing nature of parental responsibility. Historically, males had complete control over their children in the same way that men had complete control over their wives. However, with the increasing women's rights movements, women began to in fact be favoured by the courts during divorce proceedings. The vast majority of parental settlements were favouring women. In 2006, I know that's cut off. In 2006, the Family Law Amendment Shared Parental Responsibility Act introduced the concept that parenting should be shared equally between male and female. So instead of having a bias towards men as it was a long time ago, or bias towards women as it was more recently, it changed that to make it shared. So Section 60CC, Section 60B and Section 60B2 are all instrumental in this area. Section 60CC says the primary consideration for determining the best interest of the child is making sure there's a meaningful relationship with both parents. Section 60B says the best interest of the child is defined to include a relation with both parents. And finally, Section 60B2 says that children has a right to be parented by both of their parents. So clearly, the 2006 amendments are pushing for a joint relationship. Section 65, though, says that equal time will only be awarded when it is practical, and we'll have more on that later. In fact, I have more on that now, because in the case of MRR and GR 2010, a couple had moved to Mount Isa. However, they then separated, and the mother wanted to return to Sydney and take the children with her. The judge ruled that in this instance, it was not practical that the time be shared, as in week about, or 50% of the time. So therefore, in this case, it was allowed for the mother to have the majority of the caring in Sydney. Non-legal responses in this area include Dad's Link, which is all about encouraging a relationship between father and child. We also have the Women's Resource Centre, which helps women who are currently experiencing crisis and also gives them legal advice, recognising that women are often socially and financially disadvantaged coming from the end of a relationship. And lastly, the National Council of Women offers conciliation processes between father and mother to help sort out their parenting issues, and also offers supports to women in terms of legal advice and other assistance. Okay, let's look at surrogacy and birth technology. Historically, it has existed for a long time. Surrogacy is when a couple or a person has another woman give birth to the child and also grow the child. The first reference to this was in the Bible, where Abraham's wife, Sarah, I believe, was unable to give birth herself, and they used a surrogate. Under the Status of Children's Act, it only recognises two parents only. So this creates an issue where you have essentially three parties, a mother and a father, and then a surrogate mother who is bearing the child. So the law will only recognise there being two parents. Normally, this is easier to determine because the mother is the one who gives birth, but in surrogacy, obviously, this is going to differ. So the key piece of legislation for this is the Surrogacy Act 2010. First of all, and most importantly, Section 23, or pursuant to Section 23, it outlaws all commercial surrogacy. You cannot pay money for a woman to bear a child for you. First of all, secondly, Section 6 says the birthing mother must give consent. The birthing mother must also be of a certain age and must also have been done with giving birth to their own children or having their own family. And they must also undertake a psychiatric assessment. This is to ensure that they're in the fit and proper mental condition to undertake a very emotionally traumatic process. Also, pursuant to Section 6, while commercial surrogacy is completely outlawed, parents can pay for the cost of the birth. That can be things such as the hospital, maternity leave, maternity clothing, maternity leave, these sorts of things. So there can be some money change hands to help the mother, but no money directly change hands for the baby. Lastly, Section 17, counsellors must review the arrangement, and Section 16, if everybody is happy and consent is given and there is no commercial surrogacy, the court will award parentage orders, which will make the commissioning parents, the legal parents of that surrogate child, of the child who was born through surrogacy, these must be applied for between 30 days and 6 months after the birth. International surrogacy poses an interesting complication and is something that essentially is a loophole in this entire system. Commercial surrogacy is happening a lot in the developing world, places like Thailand and India. people from Australia are travelling there and are paying for somebody to be the surrogate mother. The court obviously says no, because under the Surrogacy Act you can have no commercial transaction. However, under the best interest of the child, it is potential that the court will allow it. So the court can be posed with the position of saying the child will not have cannot be made the surrogate in Australia because of commercial surrogacy, but the mother says, I will not look after it. I had only entered into this agreement on the basis that you would take the child from me. So the court is left considering, will I let this child be homeless on the streets of Thailand or India or another place, or will I allow them to come to Australia and be cared for by these Australians? And mostly, they in fact are allowing them. However, parents may suffer criminal sanction for this, but they still will potentially be made the legal parent of this child through a commercial surrogacy commissioned overseas. This was the case in Dudley Anor and Chetty, where a Queensland couple did exactly that. The mother in Thailand said that she would not look after the child, and the court then allowed the child to move to Australia and cared for. However, the parents did face some criminal sanction. Okay, obviously the most high-profile part of this is the baby gammy case, where a couple went to Thailand and they had twins, and one child had Down syndrome, that is baby gammy, and they left the child with Down syndrome, taking the otherwise healthy baby back with them. And this shows some of the perils of the system. Yes. Okay. So non-legal responses include the surrogacy sisters. This helps women find the surrogates, the altruistic surrogates, women who are willing to offer their bodies for the process. And also, Surrogacy Australia will also help find surrogates, but they will also commission pressure governments to change laws to ensure that there's better laws and better safeguards for both child and for parents. Okay, lastly, care and protection of children. So historically, there was no such thing as childhood. Children were just seen as small adults. Check Oliver Twist if you don't believe me. That is a book written largely about that. However, with the Convention of the Rights of the Child, or CROC, we now have the best interests of the child, and this has been inserted into a number of pieces of Australian legislation, most significantly Section 60 of the Family Law Act, which basically says that all decisions concerning children must be in their best interests. So, what this means is, particularly under the Family Law Act, it will limit parenting access to children or capacity to care for child if there is any violence present in the family home. And Section 4AB defines family violence very broadly. This could include having to clean up after the violence has occurred, having to call the ambulance, these sorts of things. So even if the violence is not enacted upon them, or if they don't actually witness the violence, they will still be counted as experiencing that violence, and therefore that will limit the violent parents' access to those children. However, the most important piece of legislation is the Children, Young Persons Care and Protection Act, which is the New South Wales Act. So Section 8 of this says that the purpose of this act is to make sure that children have a safe, stable and non-violent environments. So to achieve this, Section 27 introduced mandatory reporting, which says that anybody who has direct care and responsibility for children, teachers, priests, police officers, doctors, must report if they suspect there is abuse. Section 30 allows the Department of Community Services to investigate, and Section 43 actually allows the police to remove those children if there are reasonable grounds to suspect that they are being neglected or abused. So according to the Australian Institute of Family Studies, in 2013, 40,000 children were living in out-of-care arrangements. So these are children who had been removed at some point in time and were placed in the care of foster families and away from their families. Section 95 to 105 of this Act also places special conditions for children who go to court. These are things like the courts being closed, children having the proceedings explained to them, having somebody present with them. So children are also treated differently in the way that they when they experience criminal justice. A good example of children being removed and docs intervening is in Iron Elm 2006. This is where a woman arrived from Africa, I believe, and she had AIDS. She had contracted AIDS, and her child, she was pregnant at the time, and her child was likely to have AIDS too. She was refusing to take her medication to treat AIDS or to control the symptoms of AIDS. and was also said that she would refuse to give it to her child when the child was born, claiming that God would cure her. On this basis, docs did in fact investigate, and the child was eventually removed. And this is an example of the powers that the state has pursuant to the Children's Young Persons Care and Protection Act. Finally, the non-legal responses include Bravehearts. Now, this is a group that says that it aims to remove all child abuse by 2020, I believe, to make sure that all children are free and live in safe and stable and supportive environments. Also significantly at the moment, we have the Royal Commission into Institutional Child Abuse, and this is investigating particularly Catholic Church or boarding schools or even hospitals where children in the past have been routinely exposed to some sort of sexual abuse, and it's all about investigating that, exposing what had happened. There will be criminal charges eventually against people who have been found to have done the wrong thing. However, it will also make recommendations to the government to prevent further institutional sexual abuse in the future. Finally, and very last, we have a case of child sexual abuse in 2015 where a psychiatrist was abusing their patients, as particularly a child, was abusing one of the children patients because the child was, and they were saying it was some sort of psychological treatment, but it did essentially amount to sexual abuse. So these things do continue to happen. Okay, so that is everything in a nutshell. I trust that you review this a number of times. Please review your notes for more accurate recollection of this sort of stuff, but that is essentially it.